Hi, my name is Kyle Ingram, and I work in the area of federal employee disability rights. A lot of employees have difficulty when they ask for reasonable accommodations that management will come back and say, we can't provide this particular reasonable accommodation because you will not be performing an essential function of your job. Well, what is an essential function? Why are they talking about essential functions in the first place? The agency has an obligation to provide reasonable accommodations for employees with disabilities. However, if the employee is not going to be able to perform the essential functions of the job with that reasonable accommodation, then they're not entitled to the accommodation. That would be the case, for example, if that reasonable accommodation would prevent them from doing an essential function of their job. When might that happen? Well, for example, if somebody works in an office where they have to perform some physical act in that office, they can't also request telework for that time. They have to be in the office to perform some function of their job. So for example, somebody who is an administrative assistant typically has to do mail work. Well, mail work is something that you need to physically be present for. Picking up the mail, opening the mail, delivering the mail to whomever it is addressed to. What that means is that that person cannot get an accommodation for telework for those times when she is expected to be in the office. The problem is that a lot of agencies, and particularly management, don't understand how this all applies. Just because somebody has an essential function doesn't mean that they're doing it all the time. Just because somebody has an essential function doesn't mean that they can't think creatively about how to accommodate that essential function. Sometimes management will manipulate essential functions in order to be able to deny a reasonable accommodation to an employee. There are three forms that this typically comes in. First, creating a new essential function, something that hasn't existed before. The second is resurrecting old essential functions that are being dusted off purely for the purpose of denying a reasonable accommodation. And the third is expanding existing functions, legitimate functions, so that they become something that can justify denial of a reasonable accommodation. So the third is perhaps the most common. Expanding an existing essential function so that management can deny a reasonable accommodation. So for example, if somebody needs to be in the office once a week to handle mail, using that need, using that part of the job, that essential function, to justify denying any telework, right? That's expanding that essential function to the point where the agency is accomplishing what it wanted to, right? Management is getting what it wants out of this, which is to deny a reasonable accommodation. There is a recent case from the EEOC shows how this sometimes works and why agencies really shouldn't be allowed to do this. I'm going to put the case down in the notes below this video so that you can find it. The case is Hayti versus Interior. In this case, the employee was a park ranger interpreter. That meant that once in a while she had to be in the office to be able to do her interpreting work, face-to-face kind of work. That is an essential function of the job. She has to be able to do the interpreting work. That's the reason that the job exists. However, as came out in the facts, it didn't require her to be at the office all the time. She requested situational telework to allow her to telework from home if and when she needed it, consistent with being able to come into the office to be able to do her interpreting functions. Well, the agency denied blanket, wholesale, any telework accommodation for her. She went through the EEO process and appealed this up through the EEOC, and the EEOC agreed with her that denying a telework accommodation that was not 100% full-time telework on the basis that from time to time she needed to be in the office didn't make sense. The essential function is interpreting. She's required to do it once in a while, once or twice a week. If she is prepared to be in the office those times and otherwise can perform the other essential functions from home, that is a reasonable accommodation. The essential function of her job was to interpret. Her accommodation takes that into account. Therefore, by denying the accommodation for the rest of the time when she didn't have to be in the office, such as when she was doing paperwork, the agency denied her a reasonable accommodation. That's discrimination under the ADA and the Rehabilitation Act. So what can an employee do? If you're facing a situation like this, there are a few things that you can do. The first thing is to gather information. Understand what it is that they claim are essential functions. Are these essential functions for other people in similar situations? Are these essential functions that could be given to somebody else without changing the fundamental nature of what your job is? The second is to engage in the interactive process with management. Point out to management how a particular accommodation is consistent with the essential functions, and challenge those essential functions that have been expanded beyond what they really are. Don't allow the agency to simply point to a position description and say, aha, that is an essential function of your job. If you're not performing an essential function, it can be important to point that out to management because they may not be aware of that. If you are no longer performing a particular essential function that is listed in, for example, a position description, then it can be important to notify management about that so that they can adjust their expectations in line with that. And management may not know that this essential function is no longer being performed. Modifying a reasonable accommodation request to meet the needs of what are truly essential functions can help in smoothing the process for an employee to get that reasonable accommodation. However, there are going to be situations where management simply does not want to provide a particular accommodation. And in that case, the employee's last line of defense is to file an EEO complaint. Contact your EEO counselor, and do so within 45 days of the denial of any reasonable accommodation. That is what ultimately protects employees from discrimination based on failure to accommodate. If you are facing a situation like this yourself, I strongly recommend that you reach out to an attorney to help you out with the process. There are many other issues that go into reasonable accommodations that I haven't had the time to cover here today. It is important for employees to understand what their rights are so that they can act to be able to protect those rights before something happens that may affect their job.